I know where you live. I got y'all. And the complainants feared for their lives, believing the defendant would return to cause them bodily injury. The defendant grabbed the complainant by her hair and pulled her to the ground, causing pain.
Stop.
I'm sorry. Let's go out of jail.
Okay. I'm now revoking your bond. Goes with you.
Welcome to Bench Report Court Cam.
It's Schreiber.
Yes, sir. Judge Kyle Schreiber.
Come on up, Mr. Schreiber. Good morning, sir. Sir, you're charged with harassment. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On January 16, 2025, the officers made contact with the complainant at a residence in Harris County, Texas, who stated the defendant came to the cul-de-sac on a dirt bike, began revving the engine, which got the complainant's attention, and the complainants began recording the incident on their cell phone. The officers reviewed a video from the cell phone showing the defendant sitting on a dirt bike, continuously revving the engines, and the complainants made contact with the defendant, and the verbal argument began. The defendant made the comment, "It's y'all asses. I know where you live. I got y'all." And the complainants feared for their lives, believing the defendant would return to cause them bodily injury. The defendant's residence is only 0.7 miles from the complainant's residence.
Judge, I think the facts are going to show this stems from a confrontation that the neighbors had with his children, and that there's more context to the alleged threat that explains that. However, my understanding is...
So are they next door neighbors?
No, they live in the same general neighborhood, but there's already a pretrial bond condition of no contact.
Got it.
And I've explained to Mr. Schreiber that staying away from them is good.
Really, that's all we're asking you to do. You know, you've got a great lawyer. Listen to him. He'll take care of you. I am going to find that there's probable cause to go forward with the case. Just don't have any weapons, don't have any contact, and all will be well. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Downey, and he'll tell you when you have to come back to court. If he tells me he can't get a hold of you because you've taken off, I'm going to issue a warrant for your arrest. Just don't pick up any new cases, okay? We'll have you sign a receipt with Victoria. We'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go. All right? Judge, thanks, guys. Please. Can you file the no contact?
Yes, Judge.
When we had the printed docket, it was missing the first two pages.
One minute, I'm almost done.
You are Raul Chavez. Mr. Chavez, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On January 15, 2025, officers are dispatched to a family disturbance. And upon arrival, the officers met with the complainant, who stated that she and the defendant started arguing over the defendant, accusing the complainant of cheating on him. The defendant stated that the defendant grabbed the complainant by her hair and pulled her to the ground, causing pain. The defendant then wrapped his arms around her neck and later struck the complainant several times in the stomach. The defendant admitted to wrapping his arms around the complainant's neck for approximately 3 seconds.
Mr. Chavez, I'm going to find that there's probable cause to go forward with the case. It looks like a protective order has been issued in this case. I would get to know it. If you violate this protective order, the state can, possibly will file a violation of a protective order against you. It's one of the worst cases you can pick up. I am ordering you also not to have any contact with this person and not to be in possession of weapons. If you violate this, I will put you in jail by revoking your bond. Do you understand?
Yes, Judge.
Can you file no contact and no weapons, please, Alex? Did you need a court-appointed lawyer, Mr. Chavez?
I thought I did have one. I already spoke to someone. I think his last name was Torres.
You don't have a court-appointed lawyer. Do you want one,
Spoke with
though?
him when I was in jail.
It's just,
That was for magistration purposes only.
I do need one.
Okay, we'll appoint your lawyer today. I've got an affidavit already on file. All right, just take a seat for me. Do not leave until you sign our bond conditions and then after you've spoken to a lawyer. Okay? Take a seat.
right this way.
Oh, wait. No, he needs to sign a reset first.
Good morning.
Mr. Hayes, you were charged with assault of a family member. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Actually, you're charged with 2 counts of assault. You're facing up to a year in jail and or a $4,000 fine. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On June 3rd, 2024, the officers were dispatched to an aggravated assault call, and the officers met with 2 complainants. The first complainant was in a prior dating relationship with the defendant. The second complainant is the first complainant's mother. The first complainant stated the defendant and her were at a party when the defendant started to become upset, and the first complainant was not responding to his advances. The 2 got into a verbal altercation, and during the verbal argument, the defendant punched the first complainant in the face several times, causing pain. The second complainant stated she observed that the defendant and the first complainant were in a verbal argument and went over to intervene, but was struck in the face with a closed fist by the defendant, causing pain. The defendant then left and returned with more family members, and the first complainant stated the defendant continued to assault her until gunshots were heard and the defendant fled.
Hey, stop.
I'm sorry.
Do we know if alcohol played a part in any of this?
There are no allegations of alcohol, Your Honor.
Mr. Hayes, I'm going to find that there's probable cause to go forward on both of your cases. In both of your cases, protective orders have been issued. I would get to know them. If you violate the protective order, the state can and probably will file a violation of a protective order. It's one of the worst cases you can pick up. Do you understand? I am ordering you not to have any contact with either of these people at all throughout the duration of this case and not to be in possession of any weapons. I'm going to do everything in my power to protect my public at all costs. Be aware of that. If I find that you pick up a new case, you endanger my public, I will revoke the bond, put you in jail, and I'm going to make them extremely high. You have a lawyer. I don't know where your lawyer is, but because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with the lawyer. If the lawyer tells me he can't get hold of you because you're playing games, you're not responding to phone calls, text messages, I will issue a warrant for your arrest.
Okay.
For now, I'll have you sign a reset. We'll have you take a seat while we get your bond conditions. We'll have you sign it, and then we'll just wait for your lawyer to get here, sir.
That my lawyer's gonna be coming here.
I don't know. He's not here yet, so hopefully he shows up. Mr. Lestrep, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On September 16, 2024, officers were dispatched to a Walgreens in Harris County, Texas. The officers spoke.
Same Walgreens as always?
Yes, Judge, it is. And the officer spoke with the complainant, the store manager, who stated she knows the defendant by sight and name. The complainant was able to identify the defendant and stated the defendant is a habitual shoplifter at the location. The defendant has a trespass warning from January 24th, 2024. And on the 17th of January 2024, the defendant stole a total of $145.81 in merchandise. On the 24th of January, the defendant stole $100.71 worth of merchandise. And on July 17th, 2024, the defendant stole $105.80 worth of merchandise. On August 1st, 2024, the defendant stole $43 worth of merchandise. And on August 15th, the defendant stole $70 worth of beer. On September 16th, the defendant stole $70.49 worth of merchandise. On November 30th, 2024, the officers stole $30.25 worth of beer. The total value for all thefts was $506.86.
Come on, jail.
Mr. Lestrep, I'm going to find that there's probable cause to go forward with the case. I'm ordering you not to go back to this Walgreens. I'm putting an ankle monitor on you right now. If I find that you violate this, you go within 1,000 feet of this store, I'm going to revoke your bond. I'm going to put you in jail. No more PR bonds. Do you understand, sir? 1,000 feet, you're not to go within this Walgreens. Do you understand?
Yeah.
I will provide you a lawyer today, Mr. Lestrep, but I'm done. This is it. Do you mind reaching out to the mag for Mr. Lestrade, please? Okay, I'm going to have you sign a reset. You'll get with Fleischer for your bond conditions, and then I'll have you talk to lawyer here momentarily, Mr. Lestrade.
Judge, what are the other conditions other than the refrain?
That's it. Just don't go over there. He gets it on today.
Yes, what is-
Mr. Jackson, you now stand charged with another case. You were charged with possession of marijuana. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On January 18th, 2025, the officer observed the defendant's vehicle traveling 78 miles per hour in a 60-mile-per-hour zone, have an expired registration, and failed to maintain financial responsibility on Interstate 45. The officer noticed a prominent odor of marijuana trailing the defendant's vehicle, and a traffic stop was initiated. The officer observed the defendant to be in the driver's seat with a black bag and a female to be in the front passenger seat. The defendant rolled down the passenger window, and the officer observed a cloud of smoke emitting from the vehicle with an odor of marijuana. The defendant was asked to step out of the vehicle with the black bag. The black bag was opened, and the officer observed a clear jar with a green leafy substance known to be marijuana based on training experience, along with a digital scale and individual baggies. The defendant was searched for weapons, and the officer found more packages of marijuana inside his private area. The weight of the marijuana was 1.82 ounces.
And Your Honor, if I could adjust probable cause.
Okay.
Your Honor, so while I don't dispute the reason for the stop here, I think there's a couple things that stand out. So there is a alleged smell of marijuana that comes from the vehicle, and then an alleged cloud of smoke that comes from the vehicle as the windows are open. So first off, the officer doesn't specify whether this is a cloud of course, burnt marijuana, which I would assume, or vaped marijuana, because those are two very different things with two very different distinct smells. Additionally, if the officer is pulling him out and looking for marijuana and he has this cloud, then he would be looking for burnt marijuana, right? So he would be looking for a roach. He would be looking for a blunt. What he does is he looks inside of a plastic bag. If we have embered marijuana or we have a lit blunt, it's certainly not going to be in a plastic bag without the smell of burning plastic. Additionally, the marijuana that is found in the bag is in a sealed glass jar container, something that would not emanate a smell because a glass jar is essentially smell proof. In this instance, I think we have an officer who went too far with the search because we have Mr. Jackson here who did not admit to possessing marijuana, did not admit to this being marijuana. The statute, of course, requires that this has to be marijuana, and we know we have the issues, of course, with the hemp bill. But Your Honor, if you're not aware, you can go into any head shop, purchase flowered hemp, open it, and it smells, looks, everything about it is identical.
I understand,
to
and that,
marijuana.
yes, I agree with you for a beyond a reasonable doubt standard, but here, this is just mere probable cause, right? There's a good stop, he goes to the car, smells marijuana, there's a plume of smoke that comes out. Not only that, Sean, he signed an affidavit that he wasn't going to drive. He's not supposed to be driving regardless.
And I get the driving aspect of it, but I don't see how a cloud of marijuana from burnt marijuana gets you inside of a plastic bag. At that point, it becomes a fishing expedition as opposed to looking for the actual contraband, which he suspects that would be in the vehicle.
I don't know. I mean, I think that there's certainly enough to go forward. Beyond a reasonable doubt, I don't know. But this is just a probable cause standard, which is the low stand, you know? So
I understand.
I'm going to find that there's probable cause to go forward with your case, Mr. Jackson. I ordered you not to drive. He's a driver in this car?
Yes, Judge.
Okay. I'm now revoking your bond. Goes with you. Sorry, Sean, but you know, he promised us he's not going to drive. He signed an affidavit. He knows. He knew.
And Your Honor, will a new bond be set? And if so, can we get that amount set?
So I'll leave the first bond as is. The first case, I'm going to do it at 5,001.
Okay. So first case, 5,001, and then the new case, of course,
I'll
would be
leave the
bonded out
first
as.
one or the second one as is, though.
Which case number? Which case number?
So the one that's on page
14 or 13?
14, that one gets revoked to 5,001. Yeah.
Okay. Okay. Thank you, Your Honor.
Okay, thanks,
I believe
Sean.
That's all.
You don't have anything else with us today?
Nope. I'm in Fort Bend for the rest of the day.
All right, good luck, my friend.
Thank you, Your Honor. May I be
Weekend.
excused? You too.
All right. Bye.
Thanks for watching. Stick around longer and click the highlighted videos to your right. See you there.